This is Senior Living Today with attorney Jeffery J. Rokisky.
Welcome to this edition of Senior Living Today with the State Law and Nursing Home Planning attorney Jeffery J. Rokisky. Hi, I'm your host, Kelly McCoy. We want to say thank you for the continued response to these shows. Not only have we been tackling your state law and nursing home planning questions for the past couple of years now, but we're also delving into the very complex issue of oil and gas rights, which is exactly what we are doing here once again today. But before we get to all of that, let's talk a bit about attorney Jeffery J. Rokisky. He was born and raised in the Ohio Valley and graduated from West Virginia University with a degree in accounting. He's also a graduate of the West Virginia University College of Law and holds a master's degree in tax and estate planning from the University of San Diego School of Law. Jeff is a member of the National Academy of Elder Law Attorneys and is a member of the West Virginia, Pennsylvania, and Ohio State Bars. He has offices in Weirton, Wheeling, Morgantown, Robinson Township, Pennsylvania, as well as Clarksburg and Elkins, West Virginia. Jeff's been named Best of the Best in Estate Law by readers of the Weirton Daily Times many times over the past several years. Now, once again, we're going to get to that very hot topic of Marcellus Shale gas rights. Jeff, this is what people are talking about. Many say this could change the face of the economy in the region and here in the Ohio Valley. So let's get right to our first question, which comes from Alan, who is from Jefferson County. He says about 3 years ago, he signed a lease with a gas company who told him they were going to drill a successful well on his property. Then they paid him $10 an acre and 12.5% royalty. Now, many of his neighbors, he says, have recently signed leases for not only much more money, but a higher royalty. The gas company he signed with sold the lease to another gas company. He wants to know, is there anything that he can do now to get out of this lease, Jeff?
We hope so, Kelly. It seems that everybody that we've talked to that has been fortunate enough to sign a good lease, a fair lease, there's been somebody who has essentially been taken by a gas company, or what we call a flipper, somebody who signed somebody up for a very low amount, no intentions of ever drilling on that property, fully understanding what the landowner had, even though the landowner didn't, and then taking advantage of that knowledge and assigning them to a very poor lease, and then assigning the lease to an actual company that will do the drilling, and making a lot of money on the difference between what the landowner agreed to sign with them and what they were able to assign to an actual gas company that will do drilling. There's two schools of thought there. First of all, if there were any misrepresentations that were made by that flipper or landman in inducing the landowner to sign the lease, the same contractual issues exist with fraud. In other words, they were induced by fraud to sign that lease, and they may be able to set aside that lease under those circumstances. So in other words, if they made misrepresentations, made false statements, it is possible that the lease can be set aside under those circumstances. The second theory is that just the fact that these landowners were grossly underpaid to begin with, that there was inadequate consideration. And the standard seems to be in that area that the amount that they were paid shocks the conscience. And certainly if we have somebody who's getting $10 an acre and 12.5% royalty, which is the bare minimum by state law, I mean, they have to be paid that amount. I think that there's a strong argument that they really weren't paid anything at all, and therefore there's not a binding contract, and therefore they may be able to take that contract to court and possibly set it aside. My firm, we come across this, like I said, almost on a daily basis. What we're doing is we're working with firms of litigators, very good litigators, who are going to look at these leases with us on a kind of a case-by-case basis, see if there was any misrepresentations that were made, compare the consideration that these people were receiving, what they actually probably should have been receiving, and possibly, file an action in court to set aside these leases. So it's certainly something that our firm's looking at in conjunction with other firms, and hopefully we'll have success, because again, a lot of these people unfortunately were taken advantage just because of their lack of knowledge.
And it was new, probably,
It was
when
new.
they signed.
Right. There's a very good article in a law review article that came out of Texas recently, and they talked about in Texas the same thing happened with the Barnett Shale, where all this horizontal fracking started. The fact that these landmen came in early, in the development of these gas wells before anybody truly understood how valuable their rights were, and did the same thing. And only after a certain amount of knowledge was gained by the community did people start to sit back and say, wait a second, we understand that we're really entitled to a lot more than our fathers or grandfathers were for these shallow vertical wells. And eventually, down in Texas, just like in this community, people started to get the money that they truly were entitled to.
Okay, now on to our next question. Mary from New Martinsville says that she just added an oil and gas seminar. She just attended, rather, an oil and gas seminar where the speakers kept emphasizing the need to have a Pew clause inserted into her lease. She says, I don't think half the audience really understood what the speaker meant by a Pew clause. What is it? Could you please explain it?
Okay, well, I will tell you that it's a very complicated concept to understand, but yet it's very important that our audience does understand. Through no fault of the speaker that she attended the seminar with, it's a complicated subject. Basically, the way the Pew clause works is, let's assume that you have 200 acres, and you sign a lease with a gas company, and they pay you $2,500 an acre up front and 15% royalty. You get your $2,500 an acre up front for that 200 acres when you sign the lease and after they've done a title search to make sure you own.
Nice piece of money there.
Yeah, very nice. I wish I had 200 acres.
So do I.
But anyways, you're going to get your money for your acreage up front, but you will not get the 15% royalty until they actually sink a well which utilizes a portion of your property. Okay, so again, the money, the $2,500 an acre, you get that up front, and then when the gas company sinks a well and your property is part of what we call the drilling unit, then and only then will you get paid your royalties. And let's say, for example, that they sink a well and they develop their drilling unit, which is generally about 640 acres to 1,000 acres, and only 20 acres of the 200 acres is being utilized as part of that unit. You are only going to get your royalties on the 20 acres that are being made productive. Okay? And so in other words, the other 190 acres that are falling outside the unit, you're not going to get paid that 15% production rate for. And at first blush, I think everybody says, well, that makes sense because, why should they pay me royalties on the 190 acres if they're not making them productive, if they're not taking gas out from underneath my land? And they're right. There's no reason you should get paid for that. The problem is this, that if another gas company comes along and says to that person, we would like to sign you up for a lease, we notice that your 190 acres aren't being used, aren't part of a drilling unit, we would like to sign you up with a lease with our company so that we can make your 190 acres productive. Mm-hmm. Without a Pew clause, you are not able to sign a lease with that second company because you're already obligated the 200 acres to the first company. So what a Pew clause does, it says to that first company, I'm going to give you my 200 acres to make productive, and if you don't make that acreage productive within, let's say, 5 years, which is very common, then any portion of my property that you haven't made productive, I'm free to go out and negotiate a lease with somebody else who might make that property productive. And so that's I know it's very complicated.
Actually, I think it's actually quite understanding how you just put, or understandable, I should say, how you just put it. But my question, Jeff, is that's something you always have to do in the offset, in the very beginning, correct?
Right. If it's not in the lease to begin with, then you can't negotiate it later on in most cases. And I will tell you, the standard lease that a gas company is going to give you from the beginning is not going to have that Pew clause in there. That is something that you're going to have to be aware of and something that you're going to have to make sure that is negotiated into the lease.
Okay, let's go on to our next question. Now, Joanne from Chester says, Jeff, I signed a terrible lease 4 years ago. In February 2012, my 5-year lease will be up. Does that mean I will be free to renegotiate better terms for my lease, Jeff?
Maybe. It depends on what her lease says. if her lease has a renewal clause, and the renewal clause, the common renewal clause that you will find in the very first lease that the gas company is going to give you without any addendums, typically would say that they can renew the lease for another 5 years, and all they have to do is pay you the same consideration that they paid you for the first 5-year lease. So if she, for example, was only getting $10 an acre for the first 5 years, then the gas company can hold her to another 5 years simply by paying her another $10 an acre. Okay, so renewal clauses vary. Sometimes you're free after 5 years to go out and seek a better offer, and if you find a better offer, then the gas company can match your offer. It really varies lease by lease, but
it's never black and white, is it?
It's never black and white, which is always why you should have an attorney, somebody experienced in oil and gas law. Take a look at it and make sure that you understand your options. And again, I have to say, you need to probably have counsel before you sign the lease, because just like in Jill's instance, she's already signed the lease. So she's going to be bound by that renewal clause unless, for example, she consults with an attorney who deems that, like we talked about with the first question, maybe that lease is something that can be set aside by a court because she was paid grossly inadequate consideration. Other than that, you're stuck with the lease that you signed.
Okay, we're talking about, that was Joanne.
That's right.
From Chester.
Yeah.
Okay, our next question is from Jill from Weirton, who says that she's heard so much about joining a landowners group. She asks what the advantages are and the disadvantages of joining such groups. She also wants to know if she can join such a group even if she doesn't want a company to actually drill on her property.
Well, that's a very interesting question. Landowners groups, there's a lot of active landowner groups right now. We have a landowners group in Hancock County. We've had a landowners group in Belmont and Monroe County. There's been articles in the paper recently about other landowners groups. And in fact, one of the very first well-publicized landowners group was the group in Brooke County that I think had approximately 24,000 acres.
Wow.
The concept of a landowners group is that a bunch of people kind of form together a group and negotiate the terms of their leases as a whole. In other words, they don't negotiate on an individual basis. They try to make a market for their group and try to get different gas companies to sign a lease with their group as a whole, kind of what we call a master lease. And the theory is, and we had Jake Polachek on as a guest a long time ago, because Jake's been active in forming groups, talking about it's just you have a lot more clout when you're part of a 24,000 acre group, for example, than if you just have 20 or 30 acres. I mean, good luck, and believe me, I've tried. Good luck negotiating a lease when you only have 20 acres. You don't have a whole lot of clout with Chesapeake or Gulfport or XTO or Dominion. They kind of yawn when you tell them you've got 20 acres, but when you throw in your acreage with a bunch of other landowners and you create a very attractive group, a very attractive target, then the likelihood that you'll get better terms I think is increased. Now each case is a little bit different, but I think historically if you looked at what's happened to some of the groups around here, there was a big group that had signed a lease. There were 70,000 acres, I think, over in Ohio, and I think they were, they got $2,300 an acre and 17.5%. Really, at that time, that was about the best lease that we've seen over in Ohio. Likewise, the group in Brooke County with 24,000 acres, my understanding, and a lot of it is hearsay because I wasn't part of that group, was that they signed a very attractive lease, probably one of the best leases in West Virginia. The advantage, let's look at Brooke County. The advantage is, and I think they got approximately $5,000 an acre, 17.5%, 18%. Yeah, it was a very good lease, at least financially. There were a lot of people who weren't part of that group, a lot of our clients who called us and who were approached by landmen for Chesapeake, that was Chesapeake still, approached by Chesapeake after that deal was done, and Chesapeake was saying to them, to the people who were calling us, we'll give you $3,500 an acre, 15 or 16%. And they were saying, hang on a second, you just paid, we know what the group got, you just paid them $5,000 an acre, let's say 18%, they're right across the street from me, how come I'm not getting the same terms? And the response that they were getting from the landmen was, well, if you were part of the group, that's what you would have got, but you're not, and therefore
less
clout, right. So that is the theory of a landowner's group, and it seems to have worked out successfully. The disadvantages are, a lot depends on how the groups are run. I've seen some groups where if you're part of the group and a certain percentage of the group members agree to take the master lease, then you're kind of bound to take that lease too. And you know, it's possible that maybe you don't want to take that lease because financially you think that you could do better, or you could do better on your own, or there's non-financial terms that you're not comfortable with. With those types of groups where it's mandatory that if 75% of the members sign, so do you, you're bound, okay, contractually bound. A lot of groups work kind of on a volunteer basis, and the groups that I'm involved with have it set up so that you get a master lease presented to the group, and if you want to take it, you can. But if you don't want to take it, you're free to walk away and either continue with the group and hope a better deal comes along, or go out and do it on your own. And I think that's a much better way to handle the group. It makes people a little more willing to join a group if they know that if they don't like it, they can just walk away. The question that she asked, can she join a group and yet not want the company to drill on her property, is a little trickier. In most cases that I'm familiar with, the gas company is going to present a master lease, and they're not going to want individual members to deviate from that lease.
Right.
And so, and a gas company by no means, for example, is going to sign a group with 20,000 acres, for example, and have it all non-surface so they can't drill anywhere, because
it doesn't make any sense.
It makes no sense whatsoever for the gas companies. So basically everybody generally in the group has to take a surface lease. Now, a lot depends on how much acreage you have. If you have 5 or 10 or 15 acres, chances are, based on the setbacks that are contained in the lease, in other words, how far they have to be away from structures. Sometimes it's 500 feet, sometimes it's 300 feet, sometimes it's 800 feet. I think at 500 feet, if that's the setback from how close they can drill to your house or any structure on the property, that excludes basically 18 acres of land around your house. And keep in mind, if you got neighbors around you, they also have kind of 18 acres around them that can't be drilled on. So somebody who has 20 acres, 25 acres, 30 acres probably doesn't have to worry about them drilling on their property anyways. Interestingly enough, I've talked to a lot of groups, and I was recently at a group one Sunday night, and we were talking, and there's about 25 people there. And I was explaining the difference between a surface lease and a non-surface lease. And I asked for a show of hands, and I asked the group, how many of you would be willing to let the gas company drill on your property? And in doing so, recognize that you're going to typically you get more money. You get what we call a spud fee, maybe $10, $15, $20, $25,000 extra because they're drilling on your property.
Okay.
And also recognize that if they're drilling on your property, chances are your acreage is all going to fall within the drilling unit, and then you're going to get paid a lot more in royalties. Okay, so I asked them, and I was shocked that probably 85% of them raised their hand and said they would want the gas company to drill on their property, that they weren't worried about damage or issues with water or the surface. And of course, if you have a properly drafted lease, a lot of those surface and water issues should be taken care of as far as damage, and if you've signed a lease with a good company. So I think that my misconception was that people were a little bit reluctant to have have gas companies drill on their property. It seems to be exactly the opposite. And when we did a deal with our Belmont County group, I actually had members of the Belmont County group call me and say, would you please tell the gas company we want them to drill on our property?
That is interesting.
Yeah, it is. So, and of course, and then there's other people. We represent people, for example, who have a horse farm with show horses, and under no circumstances, under any conditions, do they want well put on their property. So, and those people probably should not be, and I've told them that then you really shouldn't be in a group. I mean, we happen to negotiate an individual lease with you, a non-surface lease, but you can't really be part of a group when you have 300 or 400 acres. There's a good chance that they may need your property to drill on. So.
Okay, that's interesting.
Yeah.
Mike from Benwood says, Jeff, my family was very excited because we were getting ready to receive a bonus royalty payment from the lease. That is until they visited their accountant and she told them how much they were going to have to pay in taxes on the money that they're going to receive from their gas lease. Is there anything they can do to keep Uncle Sam out of their pockets? That's a good question.
It is. To some degree, once again, I'll say I only wish I had that problem.
I know, I do too, but it is a problem. You know, you get such royalties and you want to kind of keep them.
Right, exactly. There are some things that they could do. The sooner that they plan to lower their tax bill, because you can't avoid completely taxes. It is ordinary income when you receive the lease payment. But there's the possibility, in particular using family limited partnerships and limited liability companies, where you could convey your royalty rights, at least a portion of your royalty rights, to your children. For example, if you set up a family limited partnership, you can name your children as limited partners, give them a certain percentage of the royalty payments that are to be received. And so when that money comes in, it's going to be spread not only between mom and dad, for example, but between their children as well. And if you spread that out in enough different ways, typically what you're doing is, instead of one person just paying the taxes at a very high tax rate, now you have it spread out among 2, 3, 4, 5, 6 different people. Hopefully, typically at lower tax rates. Okay, and in that case, by the way, you could keep, mom, dad could remain what we call the general partner, so they can still control when their children get the money, what other negotiations have to be done with the lease. So they're still boss, so to speak, of the lease, but at least they're not paying all the taxes. Now, the thing, Kelly, is the sooner that you do that, the less trouble the IRS is going to have with that. I mean, if Chesapeake, for example, is getting ready to write those checks to mom and dad, and at the last second they say, wait a second, issue this to our children, the IRS is going to say, well, that's kind of what we call an assignment of income. You were entitled to that money, and at the last minute you tried to kind of push that off to your children. And that's risky. And so if you're going to consider doing this, you need to get some good legal and tax advice to make sure that you're doing it early enough along that the IRS isn't going to have a problem with it.
The bottom line is, we keep coming back to this, you need legal counsel before you sign these things.
Good legal and certainly good tax advice as well, yes.
From you.
Yes, I mean, obviously, we'd like people to come to us for advice.
But you just want people to be safe and make good decisions, right? In general.
Right, exactly. What's happening now is people are coming to us too late. Okay, Jeff, I got this big check and there are big checks out there, $400,000, $500,000, $600,000. What can I do to save taxes? Well, the check's already made payable to John Smith. It's too late, and you feel bad that you couldn't have done something sooner. They couldn't have done something sooner. So I guess that's why we do the show, to try to teach people that there's things that they can do to protect their assets.
So much information that's so very important. Our next question, Jeff, comes from Janet from New Cumberland. She says, Jeff, my father signed a lease almost 5 years ago, and the terms are nowhere near what she read about in the paper. The lease does not have a renewal provision, but the gas company's representatives have said that they have started to put pipelines across their property and that it's sufficient to hold their lease by production. Is that true?
It depends, and I feel bad that I have to say that almost with every answer, but so much depends upon what the lease says and how it defines production. The point is that generally the gas companies have 5 years to make your property productive. And if they don't drill a well is the easiest way to think of it. If they don't drill a well and start paying you royalties, then as a general rule, you're free to go out there and renegotiate a better lease. Unless there's renewal clauses that we talked about earlier. Right. This particular member of the audience said that there's not a renewal clause. So then the only question is, has the gas company done enough to hold the property by production? Clearly, if they sunk a well and this person was starting to receive royalty checks, they probably would be bound by the terms of the lease. That's not the case. And so as they describe it, that they're just laying pipeline across the property, that may not be enough. I guess the one question I would have for the audience member is it pipeline for your drilling unit, or are they just bringing a pipeline in from somebody else's drilling unit, in which case it's probably not held by production. There's two rules out there. There's, I think, the Texas rule and the Oklahoma rule, and each one varies on what the standard is for property to be held by production. And we don't have a whole lot of precedent in Ohio or West Virginia on what that means yet. States, of course, like Texas and Oklahoma have been down this road before many, many times, and that's why there's sufficient law in those states to look at and determine what constitutes production or not. I would tell this person that they need to quickly get to probably an attorney, have the lease reviewed, the specific terms of the lease, and see what activity has taken place on that property, and get an opinion as to whether or not they're bound by that old lease. If not, then I would assume what that attorney would do would be quickly file an action with the court and say, hey, these people should be free of their lease, should be free to go and negotiate better terms with another gas company.
Never yes and no, right?
Never, hardly ever a yes or no.
Makes your job a little bit more complicated, but that much more important, that's for sure. Okay, Jeff, our next question comes from Brenda, who is from St. Clairsville. She says, a non-attorney has started a landowners group in her township and wants them to pay him for his representation. Her neighbor said that that's not legal. Is this correct? Is that legal or not, Jeff?
It may not be. There is an opinion in the state of West Virginia by the Unauthorized Practice of Law Committee that says in order to represent people and negotiate leases, you either have to be a licensed attorney or you have to be a licensed real estate agent. And those are the only two groups of people in West Virginia who can get paid for their services. I will tell you that I believe there's a similar rule, or should be a similar rule in Ohio.
Yeah, that's what I was wondering.
Right, and so I would tell that person, that you better be very careful when you do not have either a professional real estate person or attorney representing you. And I would think there's a strong likelihood that if somebody has paid a non-attorney or non-real estate agent to represent them, there's a chance they can get their money back, to be honest.
Okay, Jeff, as always, important answers to a lot of very important questions that we're getting, and this has actually become a very familiar topic in the Ohio Valley, and keep those questions coming because Jeff certainly has the answers to them. Be sure to join us for the next edition of Senior Living Today with attorney Jeffery J. Rokisky. In the meantime, if you'd like to schedule a free consultation with Rokisky and Associates, simply call the number on your screen or visit us online at rokiskyandAssociates.com. For attorney Jeffery J. Rokisky, I'm Kelly McCoy. We'll see you next time on Senior Living Today right here on WTOV 9.
This is Senior Living Today with attorney Jeffery J. Rokisky.
Hello, everyone, and welcome to this edition of Senior Living Today with estate law and nursing home planning attorney Jeffery J. Rokisky. I'm your host, Kelly McCoy. We've been doing these shows now for a couple of years, and we really want to thank you for your response. It's overwhelming, and we certainly do appreciate it. We are proud to answer your questions about estate law and nursing home planning and various other topics facing seniors today. Let's talk a little bit about attorney Jeffery J. Rokisky. Jeff was born and raised in the Ohio Valley. He graduated from West Virginia University with a degree in accounting. He's also a graduate of the West Virginia University College of Law and holds a master's degree in tax and estate planning from the University of San Diego School of Law. Jeff is a member of the National Academy of Elder Law Attorneys and is a member of the West Virginia, Pennsylvania, and Ohio State Bars. He has offices in Weirton, Wheeling, Morgantown, Robinson Township, Pennsylvania, as well as Clarksburg and Elkins, West Virginia. Jeff's also been named the best of the best in estate law by readers of the Weirton Daily Times. Jeff, let's get right to today's estate law and nursing home planning questions. We certainly do have a lot of them, and keep those questions coming. Our first question comes from Janet from Weirton, who says, Jeff, my mother was told by the Veterans Administration that aid and assistance is not a benefit available to her because her parents were divorced. Is this true?
Well, first of all, I'm going to assume from her question that it was her father who was the veteran. And I have to be careful with that assumption. 3 times in the last 2 months, we've been approached by families where it was the woman who was the veteran.
Okay.
2 were medics, and 1 was a woman who was in military intelligence for 20 years. So,
interesting.
yeah, so assuming it is the father who is the veteran, in most cases, a divorce does cut off the benefits to aid and attendance. Now, not always. There's some exceptions. For example, if her mother was subject to abuse, physical or mental abuse, and that caused the divorce, then that is an exception where the VA will still pay her benefits despite the fact that they got divorced. So the answer is usually yes, but it's probably the attorney who would need to know, or the VA would need to know, under what circumstances did the divorce occur.
Next question. Joe from New Martinsville says, Jeff, my father, who is a veteran and resides in an assisted living facility, was turned down for VA benefits because he had too much money. My friend's father, who is in the same assisted living facility and is receiving aid and attendance benefits, even though she told me how much money her father has, which is more than my father. How can this be? A little bit confusing, a little bit hard for me to read.
Well, the question, I think, as I understand it, is we have 2 people in the same assisted living facility. One who applied for aid and attendance and was turned down because of money, and another person who had more money and is receiving aid and attendance. And I think the answer stems from the fact that the qualification for aid and attendance is no longer just a black and white issue, especially when it comes to assets. Just like with Medicaid, to be eligible for aid and attendance, you can't have too much money in the eyes of the VA. And that used to be a very objective test. And that test, the old test was if you had $80,000 more of assets, you had too much money. If you had $60,000 or less, you were safe, you could be eligible. And in between that $60,000 and $80,000 area was kind of a gray area where you never really knew what was going to happen. Now they've changed the test, and it's not a bright line test. They're looking at the veteran's age, they're looking at his cost of care, they're looking at the diagnosis, and so there's a lot of factors that go into determining how much money is the right amount of money for a veteran to have and yet still be eligible for aid and attendance. To be safe, I think the standard that we use in our office is the veteran should not have more than $30,000 or $35,000. We have not seen a veteran to date be turned down with that low amount of money. Now the good news is with aid and attendance is that unlike Medicaid, where we're sitting here week after week talking about a 5-year look back period, and if gifts made within 5 years can trigger a penalty, the VA doesn't have a look back period. So if our client has $150,000 today and transfers that money to the trust tomorrow, the following day they can apply for aid and attendance and be eligible. And so, usually we don't have issues with clients having too much in the way of assets and therefore being turned down for aid and attendance, because assets should be relatively easy to plan for. If you understand the rules, it should be relatively easy to get your veteran eligible for VA benefits by establishing trust typically or putting somebody else's name on the account. But I understand her pain, because it doesn't seem fair that somebody with more money than her father is getting benefits and she's not. The other problem is each case is decided by somebody differently who may be looking at things slightly with different standards. So there's probably 1,000 people that are deciding these cases across the nation as far as who's eligible for aid and attendance.
So there's no one way or the other.
There's no one way, and that's why we always just try to be very conservative with what we leave with our clients in just their name.
Okay, Jeff, thanks so much. Kathy from Benwood writes, my cousin went to an elder law attorney for representation for his mother who is getting ready to go into a nursing home. He was shocked at how much the attorney wanted to charge. How do elder law attorneys determine their fees, Jeff?
That's a very good question. There's probably a variety of factors that go into determining how much an elder law attorney is going to charge. You know, what is the situation that the client is faced with? Is it what we call a pre-planning case, where nobody's going into a nursing home right away, or is it a crisis case where somebody's going into a nursing home right away and they need immediate action? Usually, you know, by filing an application for Medicaid oftentimes. A lot of times we'll look into the complexity of the case. Does our client just have one bank account with $50,000 and maybe one house worth $100,000? Compared to a client who has maybe 2 or 3 pieces of real estate and stocks and bonds scattered all over Kingdom Come. So it's not just what the client has as far as the value of their assets, but how, you know, in how many different pieces or places do those assets exist. I think, you know, ethically, I think that what we should be doing is we should be sitting down with our clients, listening to their problem. What is it that they need done? What assets do they have? And then at that point, ethically, I feel that we're bound to inform them on what our charges are going to be and how we calculated our charges. What do we base our charges on? What are our services going to consist of? And then give the client an opportunity to think about it. The practice that we do in our offices, I'm very comfortable with. Typically, we sit down, we give free consultations, we listen to the client, we tell them in advance, we need you to bring in the following information. You know, I'll give them a general idea of some options that are out there, but then we always followed up in writing with a letter saying, here's your situation, here's the law surrounding your situation, here's what we're going to recommend, here's what our fees will be, here's what our services will consist of, and you make the decision on whether or not you want to represent us. And it gives them an opportunity, for example, to go to maybe another attorney and see if there's a different recommendation or a different fee for the recommendations. I think that's the only fair and ethical way to do things, yes.
Okay. All right, Harold now from Chester wants to know, how much control can you have over your assets but yet still protect them if you have to go into a nursing home? Interesting.
Yeah, good question. I would tell Harold this, that the more control that you want to keep over your assets, the harder it is to protect your assets. Typically, we use trust in our planning process, and when you establish a trust, you can make certain decisions. For example, most importantly, who's going to be the trustee of the trust? And that person really determines how the money in the trust is invested. That person determines when there's going to be distributions from the trust to the beneficiaries. I always tell my clients, think of a trust as a locked box, and the trustee is the one who holds the keys. To the extent that mom and dad want to be the trustees and they want to have a lot of rigid control over that money, there's always the chance that somewhere down the road the Medicaid authorities are going to say that they have too much control and that those assets in the trust truly are theirs. And so when we establish these trusts, we try to work with the parents and find out just how comfortable they are with their children holding those fiduciary positions. In most cases, our clients are extremely comfortable with their children holding those positions. Quite honestly, Kelly, I like to say this, that if our clients didn't trust their children, they probably wouldn't be in the conference room to begin with trying to figure out how to protect their assets for the children. So we try to give the children as much say in the process as possible, but always the overriding theme is to our clients, we only want you to be comfortable.